was knowing who I am. And when you're young and you're in your 20s, you're trying, at least I was, you're trying on personalities like their shirt.
Welcome to my channel over the weekend, actually. Friday night, Jed Wallace filed his amended complaint, and also over the weekend, you'll never believe what happened. Do you guys know that back in 2015, Ryan Reynolds said that he was hit by a car, and he accused this guy that's a paparazzi, pretty well-known guy that worked in Vancouver, and he worked for this television show. And another version of like E.T. in Canada where he was like the photojournalist. And his job was to get photos for various outlets. And so he said that this guy hit him with a car and the guy got arrested. And then subsequently, like a couple years later, the charges were dropped. Do you guys remember that? And Ryan went all public and he was like, he got a sore knee and this and that. Well, that photojournalist actually reached out to me and I had a really long conversation with him, and I'm digging through the mountains of evidence this journalist and photojournalist sent to me, and it sounds like they lied, at least from all the evidence. I'm seeing Ryan and Blake lied about what happened in the car. The charges were eventually dropped against him because there was no evidence. And it sounds like they tried to ruin this man's life, very similarly to what is happening to Justin Baldoni. So it appears this is a trend for them, and apparently they made statements to police in that case in Canada that were just completely false. So apparently their history of lying and deceiving authorities and courts doesn't just happen in the United States, it also allegedly happened in Canada. We'll dive into that more later. I also got quite a bit of tea from him about he shot Ryan and Blake for years for these various outlets, and he was on the sets of various films that were filmed in Vancouver watching, and he saw a lot that went down. And there was a lot of issues between Blake and Ryan's relationship and Ryan's jealousy and having to show up on set to monitor his wife has been going on for years, and it's not a secret. People just on the sets don't talk about it because of NDAs. On the legal front, Jed Wallace filed his motion or filed a new amended complaint against Blake Lively, and it's in Texas, and he's filing it in Texas because that's where he lives. And a lot of his amended complaint has to do with establishing that Blake came to Texas, tried to sue him in Texas. And this is why the jurisdiction needs to be in Texas. On top of that, he goes into how Blake used a faux complaint that wasn't actually a legal document. It was in a draft of a lawsuit, but it was missing key points of a lawsuit to make it a legal complaint. And how this is the source of the defamation. Because Lively claims that she never defamed him, but Jed is arguing that the document that she provided to the New York Times was in fact not a legal document at all. It was a draft and it was unnecessary, and she made claims about him in that document that were untrue and defamatory, and she also violated his privacy while doing that. Jed Wallace says that his life was forever altered after the day of December 20th, 2024, when Lively published with the New York Times her complaint, not a real complaint, but a draft. Complaint that included his name and accused him of unspeakable acts he wrote in his complaint on December 20th. And before she provided the press with her 3-page employment complaint filed with the CI, California Civil Rights Division, naming Wallace and Street as respondents and alleging they had sexually harassed Lively and then retaliated when she reported the harassment, a 62-page, 203-numbered paragraph draft complaint purportedly attached to the CRD complaint listing Wallace and Street as defendants regarding 10 claims ranging from sexual harassment to breach of contract, and asserting that the harassment had taken place on the sets and the retaliation occurred in the days leading up to the film's release. Wallace and Street were never on the set of the film or otherwise involved in its production, and their limited and sole involvement in engaging public reaction to the film and its stars occurred after the film's release, not in the days leading up to it. The filings with the agency were not available online and only available to the public pursuant to a written request for public information, and yet that night at 8:48 p.m. and the day the CRD and draft complaints were filed, a reporter sent Wallace an urgent page-and-a-half email, which stated that she had learned that Miss Lively filed a legal complaint against you, alleging sexual harassment and retaliation. Among other claims, she described details from the draft complaint, including that the complaint includes extensive private text messages and emails, which include exchanges involving you, and our court records show that your clients have included Paramount pictures, which was, they say, an obscure fact not easily uncovered. The reporter demanded that we hear back from you by tomorrow by noon Eastern, and at least as early as 5:26 a.m. the next day, which is before noon on most clocks. The reporter's newspaper posted the draft complaint, which was only a draft and never filed in any court, on its website. Under the banner read the complaint. The document remains on the website. today. And she provided this information to the reporter and her newspaper. And to be clear, he says that when he refers to Lively, he means that he's going to include her agents, including her lawyers, her consultants, her husband Ryan Reynolds, and they're related entities, but not limited to Betty Buzz, Blake Brown Aviation, Gin Mint Mobile, and Maximum Effort Productions. He goes on to say that following the release by the New York Times, The Hollywood Reporter, TMZ, E! News, Variety Today, CNN, People magazine, which named Wallace Fox News and USA. Today all reported on the complaint and the draft complaint, giving prominence to Lively's allegations the next day. Additional media, including at least 3 outlets in Texas, reported on the complaints. The CRD and draft complaints, or the contents thereof, had been shared by Lively with multiple media although she granted one newspaper exclusive access to thousands of pages of text messages and other documents which were reviewed by the newspaper, as noted in a length, the article published within the hours of the draft complaint filing under the headline, "We can bury anyone inside a Hollywood smear machine."
Bury her? I mean, how many celebrities have been buried in Hollywood?
You're absolutely right.
Then on New Year's Eve, the draft complaint, which had by this time grown into a 93-page, 327 numbered paragraph document, was filed in the United States Court for the Southern District of New York. But the real complaint, unlike the CRD, and the draft complaints did not include Wallace or Street as defendants. The reason for the omission was certainly known to Lively. There was and is no evidence to statements, and they had because Street had nothing to do with it. And they claim that the lack of proof explains why 3 weeks later, Lively sued Wallace in Texas court to obtain potential evidence of his alleged involvement in the matter, even retaining one of Wallace's former lawyers to prosecute the Texas lawsuit against him. He filed a lawsuit against Wallace in Hays County, seeking to take his deposition. Lively represented to the judge under oath that she needed the discovery to understand and evaluate potential claims. Any suit filed by Lively against Wallace is supported by competent witness testimony and evidence, and swearing that without this evidence, any lawsuit against Wallace would be groundless and in bad faith or for harassment or improper purpose. In other words, she sought AI from a Texas judge, in Texas evidence from a Texan to support her false claims in the CRD and draft complaints targeting. As to Wallace and Street Texas residents, the Texas lawsuit was done purposely. She paid a fee to the clerk to avail herself of the privilege of conducting activity in Texas from 3 law firms as her representative contacts for the case, and a Texas lawsuit related directly to a claim or defense in this lawsuit that is truth or falsity and fault. As we shall see, she purposely turned away from her self-styled investigation into the truth is provative of both negligence and actual malice. So what he's trying to do with his lawsuit is strengthen the fact that, like what Blake has been arguing, is that the courts in Texas have no jurisdiction over her. And so a lot of what his new complaint is trying to point how she came to Texas. She filed this suit against me. She brought in 3 separate legal teams that were all Texas lawyers into this. She paid fees to Texas. She told under oath to a judge in Texas that she needed a deposition. Otherwise, if she filed a lawsuit against me, it would be without merit, and it would be in violation of Texas law because she didn't have the evidence that she needed to actually sue me. And then he spends a lot of the time trying to point out she traveled to Texas. She went to South by Southwest for the Another Simple Favor premiere. She interacted with a protester who told her that justice for justice and that Blake lies. And that Blake continues to double down on these claims of defamation. So she was in Texas confronted by a Texan about the falsity of her claims, and she didn't deny it, and she didn't correct it. And that she then went and interacted with Chuck. And Joanna Gaines, he's really just trying to say, like, she was in Texas, she made herself a part of Texas, she became a party in Texas so that she can't fight, that Texas has no jurisdiction over her. That's really what a lot of what he's trying to do in this lawsuit is. But I think what is most interesting to me is that he says that she goes to the courts in Texas and says that we need to take these depositions, or else if I sue him under Texas law, I'm going to be doing this in bad faith. And it would be harassment, but then after she went to the Texas judge and asked him for the deposition, it was at that point that 3 weeks later she dismissed the lawsuit. And she falsely claimed that the court in New York, the federal judge in New York, told her to dismiss the case and bring it to New York to consolidate, which is not what Judge Lehman said at all. So he says Lively dismissed her Texas lawsuit falsely, actually preposterously claiming to the court that Ballon's lawyer in a hearing in the New York case suggested that she do so. And then without any evidence, and knowing obviously that neither Wallace nor Street had sexually harassed or retaliated against her. her for publicizing the allegations or breached a contract with her. She joined Wallace and Street in the New York complaint as defendants claiming that Wallace and Street intentionally violated her rights under California Fair Employment and Housing Acting with malice, oppression, and fraud. What Blank has really been doing. I had an opportunity to speak to Omar of A Tilted Lawyer, and he's a civil attorney. And I was talking to him over the weekend about all these different forums that she's going to. And really what Omar said to me is she's forum shopping. She is seeking information in various forums and seeking benefits from forums that other forums, which is like the state or the federal court in that area, don't have. And so she goes to New York for her subpoena because New York has different laws for subpoenas that she wouldn't be able to do or get away with in California. And in this case, in order to sue Texas in Texas and to get information from Texas, she has to abide by Texas law, and she cannot sue him unless she has grounds, or else it's deemed harassment and in bad faith, and so she's forum shopping, and so she went to Texas, and now she wants them to throw the case out saying, I never went to Texas. And she's misrepresenting things because when she filed the CRD complaint, Jed was listed in the complaint as a defendant. She outlined all of these different claims, and she really failed to differentiate who did what, and she called them and lumped them into groups like the Wayfair parties, the defendants, and using blanket terms, which the average reader might read and see. Oh well, Jed Wallace was obviously part of this campaign, and he sexually harassed her. She wrote that Wallace and Street acted despicably, maliciously, fraudulently, and oppressively with the wrongful intention of injuring.
Okay, so I will start by saying during the screening, there wasn't a dry eye in sight, and it was
Miss Lively. She branded Wallace as evil, claiming he had no regard for the rights or safety of Lively and others, and intentionally caused her extreme emotional distress, while also she claimed that he placed her in a false light, forgetting perhaps that neither Texas nor New York, where she lives, recognize this claim, which is without merit in any event. After this lawsuit and after she sued Wallace and Street in New York, Lively accompanied her publicist Leslie Sloan and Jamie Kendall to appear at South by Southwest in Austin, and that she was confronted by a Texas resident who stated Blake lies justice for Justin. Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming plaintiff. Spy, at the very least, implication. And then they also say, like I said, she went and visited Jip Chip and Joanna Gaines. And then on February 5th, he demanded that she retract and clarify her or correct her defamatory statements made by her. And on March 7th, she availed herself of her rights under Texas law and demanded certain information from plaintiffs under the statute. Plaintiffs complied as of this filing. She's neither retracted, clarified, nor corrected her defamatory statements even, though she knows that plaintiffs had nothing to do with this and they didn't sexually harass her, and further knows that she may avoid punitive damages for her part of the claim if she were to retract again, availing herself of the protection afforded under the law. So what the biggest argument they're going to use here for laying the groundwork as to how she defamed him through the draft complaint is that the draft complaint wasn't an actual legal document, and the complaint that she provided to the New York Times, where they called it a lawsuit, and subsequent outlets referred to it as a lawsuit, even though it wasn't, it was just read the complaint that was actually not a legal complaint, but a draft complaint. And so it says the draft complaint was missing several indispensable components, such as the name of the court, the cause number, the causes of action, the prayer for relief, including a statement of damages, the signature block for Lively's lawyers, although they were listed on the first page as customary in California, but not New York, where the case was ultimately filed. A week later, she used ambiguous group pleadings, Wayfair parties, Wayfair team tag, digital team Baldoni, were of team respondents and defendants that left the reasonable reader with the impression that the causes of action, severe ones of sexual harassments and violations under California and federal law, were attributed to him. He also says that statements that she made in the draft complaint are false. So he says that in the first paragraph, she says a Texas-based contractor who weaponized a digital army around the country to create, seed, and promote content that appeared to be authentic on social media platforms and internet chat forums. He says all of that is false except for him being a text-based contractor. He also says that it falsely states that Mr. Jed Wallace, an independent contractor based in Austin, Texas, was retained by TAG to perform social media services on behalf of Wayfair and Mr. Baldoni in connection with TAG's engagement. It says that he is an independent contractor, he is based in near Austin, but he is not retained by TAG for any purpose. and it was false to say so. He also says the overall gist or sting of the draft complaint was that the plaintiff sexually harassed Lively and retaliated against her, and that was and is false. And she went beyond using allegations, they said, and instead she and her agents communicated them as standalone facts, and the draft complaint that she had discovered the full extent of the retaliatory campaign launched by Wayfair. This is at odds what she later told the judge that she needed his deposition to learn about his involvement in the alleged sexual harassment. They also say that Lively sought to set the record straight, to hold the Wayfair parties and associates accountable, and to shine a light for this new form of retaliation. Lively claims retaliation is about the risk of her ever revealing the truth, which she claims to be doing in the draft complaint, by shining a light and setting the record straight. And she fully intended this draft complaint, which they claim is a press release, dressed as a not fully baked lawsuit, to be taken as statements of fact, including about the plaintiffs, and she mistakenly thought that attaching it to an administrative filing she would create privilege against defamation such as this. And they're saying that with the California right to sue what she filed is not required. So he goes on to explain that there's no rules in CRD that they require anybody to attach a draft complaint. It's unnecessary for her to provide that information to gain a right to sue. And that some of the claims that are in the draft complaint were not even within the California AI's jurisdiction. And then they said that on the same day that she filed, that she attached the draft complaint, the Civil Rights Department issued her what's called a right to sue letter. And the right to sue letter was not posted online. It was not public filing. You wouldn't even have known it was filed unless you were Lively. So there's no public filing. That this went through the only way for a third party to obtain these documents was through an FOIA, or for the applicant to provide it themselves. And they're saying Jed didn't provide that information to anyone, nor did his representatives. And he said that it's not plausible that the news became aware of it and the draft complaint through the filing. And they worked through the public information bureaucracy in time to post the draft complaint within hours of its filings, all at the beginning of a holiday weekend. And that once the Times posted it, all other media piggybacked off that post by the New York Times, and that false allegations then perpetuated around the world about Jed Wallace. Not only did they provide the CRD and draft complaint to various media entities for out-of-court republication, either directly or indirectly, but they were relied upon in a videotaped program that one media organization used to promote its upcoming article published on December 21st, 2024. Metadata within the video demonstrates the video was created prior to December 20th and made use of both the CRD and drafts complaints, despite listing 10 violations of California and federal law and alleging a major social media astroturfing campaign. She later admitted she knew of no facts to support the allegations against Wallace Street. She filed a verified petition for Rule 202 deposition in Hays County, alleging Wallace as a subcontractor to a company called TAG, and on the information of belief to assist them in their unlawful relatory social combat campaign. Against Lively, they also conceded that Lively has no facts supporting the allegations she made against Wallace, and that she needed to investigate the scope of Mr. Wallace's conduct. So it's pretty wild if you think of it in this context. She put out all of this to the New York Times before she ever filed a lawsuit, because apparently it was more important to her to get the story out than it was to file the lawsuit. Right. Generally speaking, most people that are going to proceed forward with litigation would not tip off anyone about what's coming and would wait to speak or release a statement until after something was filed. And in this case, that draft complaint isn't really a lawsuit. It was just a document that was attached to a CRD complaint, and it wasn't needed or necessary. And so that is what they say is the grounds for. You don't get litigation privilege because there was no legal complaint, and that the New York Times even screwed up because it wasn't a legal complaint. And then in order for them to establish that she should be under the jurisdiction of Texas law, what they do is they again throughout the complaint share that she was at Book Bonanza, she was in Austin, Texas, she was at Chip and Joanna, Games in Waco. She came to Texas and filed a lawsuit. They shared pictures of her in Texas. One of the most critical parts here that I think is important to highlight is that he was, for all intents and purposes, a private citizen. Yes, he does PR, and primarily he is under the radar, but he doesn't do the kind of PR that Lively believes he does. His work is primarily in crisis management, he tried to help get Bam Marra clean and sober so he could work on the film Jackass. He was like the coordinator that put together a plan that got him therapist, medical treatment, and rehab so that he could stay sober in order to film the movie. And he was hired by Paramount to help implement a strategy so that he could fulfill. His contract, that's the kind of work that he does not, this social combat stuff. And he says that all he did here was passively watch social media. He never posted anything. And so she used the fake complaint to try to shield her from litigation. Privilege, she was asked to remove the allegations, retract them. She didn't. She then later went to Texas, told a judge, listen, Jed didn't do this, and I need evidence. And then ridiculously, then brings them into federal court in New York forum shopping, where the same standards are not necessary, as in Texas for bad faith lawsuits. She forum shopped down to Texas to get a deposition. Now she's forum shopping. By bringing them up to Texas, just like she forum shopped for the subpoena, and it's the same reason why she's not suing in California, but yet now wants California protections under 47. And I have a whole video.
And so he's out, and I just really wanted my husband, because I felt weird, like something was going on, even though it wasn't. I was like, just wake up.
I could talk to you about that. But the worst part of all of this is this worse than the economic toll, is the assault on Wallace's emotional condition Lively has blasted out in court filings, in this case confidential health information about Wallace. Despite this information being sealed in the New York case and in a redacted declaration and in letters marked confidential, Wallace has suffered medical issues induced by Lively's actions. Wallace's stress began on December 20th, 2024, when his world turned upside down from the maliciously leaked CRD complaint and the draft complaint, which made totally false and fabricated allegations against plaintiffs. Such physical manifestations are the strongest evidence of mental anguish damages,